34, Simmons versus Trans Express. Counsel?
Your Honors, thank you very much. Good afternoon, and may it please the Court. I'd like to reserve 3 minutes of rebuttal
Three?
time. 3.
Of course.
Your Honor, I'm Mr. Abdul Hassan. I'm counsel for Plaintiff Charlene Simmons, the plaintiff appellant. Your Honors, the plaintiff's interpretation of the New York City Civil Code Act, Section 1808, is correct for several compelling reasons. But first and foremost among them is that the textual language strongly backs her interpretation of the statute.
Let me
As the
just
Second
clarify,
Circuit-
counsel, I'm over here, sorry. Is your position that the text is unambiguous, or that it has certain ambiguity and the legislative history then supports your reading of the case, of the language?
Your Honor, it's our position that given the issue in this case, it's unambiguous as to that issue. There might be some, as the Second Circuit pointed out, there is a further interpretation here where there is no preclusion at all. And there might be some ambiguity on that front, which can then be resolved by the legislative history. So the statute clearly states that the plaintiff can bring a subsequent action based on the same facts, issues, and parties. At minimum, that fits this case. Even if we make the point that the claims here are different and different facts, it's an even stronger case. But we don't even need to go there.
Well, what's your position, Counselor, on the 2005 amendments?
Yes, the 2005 amendment, prior to 2005, the statute even allowed a plaintiff from small claims court to bring the exact same claim, but only allowed res judicata to the amount. Despite that language, judges were interpreting the statute to preclude the exact same claim. So in 2005, the legislature brought the statute in line with the case law and, in effect, advanced the preclusion as opposed to limiting it to the amount. It says now the view was it would preclude the exact same claim, as in the Small Claims Act.
Counselor, if we disagree with you about whether, how clear or unclear the statute is, the statute itself, and we turn to the legislative history, I have to say that in all of the bill jackets I've read over the years, some of them are clearer to me than others about what the legislature intended. This one looks pretty clear. I mean, it specifically, the sponsor's memo specifically says that there's been confusion as to whether it's claim preclusion or issue preclusion, and they're clarifying that it is issue preclusion that is not allowed, but claim preclusion is. How do we get around that?
Oh, very easily. You go to the next step. When you eliminate issue preclusion, let's say you call it that, but the legislative history says two things. It says it will allow res judicata as to the same claim, and in other instances it mentions collateral estoppel or issue preclusion. When you eliminate collateral estoppel, what do? You allow claims, right? So if you take the position that you're eliminating collateral estoppel, you are necessarily limiting res judicata by allowing those claims that collateral estoppel would have precluded or dismissed. And that's especially true when you look at another important factor, what is meant by res judicata. As this court brilliantly explained in Paramount Pictures versus Allianz, res judicata had a different meaning in earlier years than it has now, that it was a very narrow concept. And it only precluded the exact same claim where there's identity of causes of action, where there has to be like a carbon copy, where is a duplicative claim.
Right, but for a long time, we've had a much more flexible analysis. We've had a transactional analysis. And we've established some exceptions to it and so on and so forth. So isn't our jurisprudence essentially saying that generally for, certain policy reasons, that if it arises out of the same transaction and so on and so forth, it will be precluded, but not necessarily, okay? That there may be situations, individual circumstances in which it's not fair to apply that doctrine. So why do you think that that doctrine doesn't apply in small claims court just as it does in any other court where neither the statute nor the legislative history indicates otherwise?
Very simple. Unlike other courts, there is a statute governing preclusion of small claims court judgments. And for this statute to have any meaning, there has to be some difference in the res judicata that's applied in other courts versus small claims court.
Well, the difference is in issue preclusion, which are clearly distinguished, again, by the legislature.
Well, once again, Your Honor, if you eliminate issue preclusion, you're going to allow claims because you don't just litigate issues in isolation.
Counsel,
For example, if you are allowed to relitigate whether you work more than 40 hours, it has to be in the context of an overtime claim. So you necessarily are going to limit res judicata. And here is what is important to look at as well. What we're trying to determine here is what the legislature intended when it adopted the statute. It's not what the general jurisprudence on res judicata is. The intent of the legislature is further highlighted by the 5 cases the legislature cited in the legislative history. And if you look at those cases, they all adopted and applied what is called a narrow species of res judicata. They use words like carbon copy. The claims have to be a carbon copy of each other.
well, counsel,
Have to
let
be
me ask you
identical.
this. Counsel, over here.
Judge
Over here.
Wilson.
With as much specificity as possible, could you tell me what the basis for the claim was in small claims court and what the basis is for the claim in federal court, and where in the record we can find that?
Your Honor, there is no record of the small claims court proceedings. But if you want me to answer the question...
I do.
The plaintiff was taken off the schedule in June of 2018. She was effectively fired. So she lost her paycheck. She felt it was wrongful. She felt that she should not have taken her off the schedule. So she, in effect, was suing for lost wages, non-payment of wages, flowing from her wrongful termination, which was her view at the time.
For what period of time?
It was for 2 months. 2 to 3
2 months
months.
following her termination?
Yes.
Okay.
So she brought that claim, and then afterwards, she came to see me. She had no idea about her overtime claim or anything like that. She was still upset about the fact that they took her off the schedule. I evaluated her case, and I said, you have some clear overtime claims here. So we did not bring the same termination claim because that was, that's what she explained she litigated in small claims court. In federal court, we brought overtime claims, which is failure to pay time and a half for more than 40 hours in a week. We brought a manual worker claim, which is a claim to recover interest and liquidated damages because she was paid biweekly instead of weekly. New York Labor Law 191 requires weekly payment of wages. And then she brought claims of wage notice and wage statement violations. So
And do any of
very,
those,
very
do any of those
different
claims, are the damages for any of those claims related to the period after her employment was terminated?
No, not at all. None, zero.
Thank you, Judge Stein, go ahead.
No, but I thought the small claims judgment referred to overtime claims.
There is a notation in the judgment that says UNPD OT ETC. Now, that could be interpreted, a jury could interpret that as overtime, or they may say, we don't understand what it means, or after hearing the plaintiff, they may say, no, it has nothing to do with overtime at all.
One other question for you. So I don't interpret the certified question as asking us to decide whether res judicata applies in this particular case. It's asking a more general rule. So, do you agree with that?
Yeah, it's asking you to interpret the statute and to
Right.
tell the Second Circuit
Okay.
if
So
it
if we
has
were-
any preclusion, some, at all, or nothing.
So if we were to decide that under this statute, the transactional analysis of res judicata applies to small claims, could the federal court still determine that it doesn't apply to this particular situation?
You mean in terms of the res judicata question or some
Yeah.
other question?
No, that the doctrine of res judicata, although it generally applies, it doesn't apply to these facts. It doesn't apply to how this case came about. You're talking about different claims, one's for overtime, one's for wrongful termination. There are different periods of time. Could the federal court say, even under the transactional analysis of res judicata, it wouldn't apply to this case?
It depends on how specific you are in your ruling, but I think the district court said that because all the claims came from the employment relationship, which spans several years, that res judicata, in its view, the traditional form of it, would preclude the claim. I don't know how the Second Circuit will view that, if it will view the entire employment relationship as covered, or if it will view the termination separately from the overtime and other violations. It will depend on how specific you are.
Well, it wouldn't have certified the question, right? Why would it certify the question if it would not matter?
It would matter, but it would...
No, following Judge Stein's question.
Yeah.
If they assumed that res judicata under the statute applied, but wouldn't apply under these facts, there's no reason to certify. Because you don't have to resolve the question.
I agree with you in the sense that if you were to say that res judicata applies, let's say, to the entire employment relationship, that would cover everything. It wouldn't, then the Second Circuit would dismiss the claim as to on the res judicata grounds.
Judge, could I ask?
Judge Fahey.
Thank you. What's the jurisdictional limit in small claims, in Queens small claims?
Your Honor, I think currently it's 10,000. At the time, it was 5,000.
It was 5,000 at the time. So was the claim that was filed for 5,000?
No, it could have been a little bit more. It was like
Did she have
8
counsel when the claim was filed?
Say what, Your Honor?
Did she have an attorney when the claim was filed?
No.
She did it herself?
She did it.
One of the keys to measuring the effect of res judicata under the common law is whether the party has had a full and fair opportunity to litigate the issues that are being raised. Are there issues that were not raised in small claims that you're saying now are being raised in your federal action?
Well, Your Honor, this was an arbitrator. There was no record of...
Right, I understand. I was a city court judge in Buffalo, and normally what would happen in that situation was lawyers who were coming into work would be, Judge Stein and I did the same kind of thing. They'd be asked to arbitrate cases. They'd go out in the hallway, they'd arbitrate the cases. They'd come back with a recommended judgment, and we'd file it. And if someone objected, they could have a trial de novo. That was a procedure 20 years ago when I was doing it. Was it the same procedure then?
I am not certain, Your Honor.
All right.
It could be
The reason
something
I ask this question is I want to know, are there issues that are being brought in the federal action that were not litigated in the small claims action?
Yes.
And what are they?
I think the issue of overtime under the FLSA New York labor law, the issue of the manual worker claim, the issue of the wage notice and wage statement claims, all of them. As far as we're concerned, the only issue that she litigated in small claims court is whether she was wrongfully taken off the schedule, wrongfully terminated, and that's what...
And the lost wages that resulted from that, I'm
Yes.
assuming.
Yeah, she needed to pay her rent,
Okay.
and she...
No,
went to
I
small
understand what you're saying. Thank you.
claims.
Thank you, counsel.
Yeah.
Counsel?
morning, Your Honors. May it please the court, my name is Emery Moore. I am here on behalf of Respondent Transit Express, Inc. to argue in favor of the majority rule. 3 out of 4 New York appellate departments, the bill summary, and legal treatises all agree that New York City Civil Court Act Section 1808 does not grant small claims judgments an exception to the doctrine of res judicata. What Section 1808 does is carve out an exception for collateral estoppel, also known as issue preclusion. We know this because the bill summary for the 2005 amendment makes that fairly clear, and here's what it says. You've read this before, but this is an important point. Clarifies that small claims judgments and local commercial claims judgments are res judicata, but shall not have collateral estoppel or issue preclusion effect in any subsequent proceeding. We also know that the offset provision is not a signal that res judicata does not apply to small claims judgments.
Well, let me ask you, over here, sorry, let me ask you about that. Can you give me an example of a case where you proceed in small claim court, you get a judgment in your favor, and you bring another claim in a subsequent court on the same facts, issues, and parties? Where are you allowed to do that? Because if you can't give me an example of where you're allowed to do that, I don't understand how the reduction provision could work at all. It's just surplusage then.
Sure. So let's take Ms. Simmons' claim for an example. Ms. Simmons filed her lawsuit in small claims court. We know that res judicata is an affirmative defense. If you fail to plead an affirmative defense, if Trans Express failed to plead that in the federal action, it might have been deemed to have waived that affirmative defense. Therefore, Ms. Simmons' claim would have been allowed to proceed. In that situation, you have a claim with the same parties, facts, and issues. And that's where the offset provision would kick in and say, okay, you can proceed with that claim, Ms. Simmons, but you can't obtain a double recovery.
Well, that's what the offset provision is for, right?
Yes.
So you could proceed with the claim then, in theory, for the amount that you didn't recover for. You're saying, no, you can't.
We're saying if one of the exceptions to res judicata applies.
Well, you're talking, it does not say that in the statute. What you're referring to, I believe, is the common law and also the, I forget the treatise that was referred to in your brief. You know better than I do. But you make a point, it's a legitimate point, but it's not a point that's reflected in the statute. And those exceptions that you point to are not in the statute. The way I read the statute, and you can correct me, is it shall be res judicata only as to the amount involved in a particular action. It doesn't say collateral estoppel, it says res judicata.
That is the pre-amendment version.
And post, no?
Yeah, it's the same language in the post, I
Doesn't
thought.
change.
Right, it says, as far as the issues, facts, and parties,
Right.
it shall not, correct.
It pretty much covers it.
Correct.
So, all right, let me posit this to you. I'm an average citizen. I get in an automobile accident. I go in and bring a lawsuit on behalf of, I had to go to the doctor for one visit, and I had $2,000 damage to my car. Go to small claims, they give me the $100 for my visit and the $2,000 for damage to my car. Under your theory, am I then precluded from bringing an action in state Supreme Court if I find out I have 3 herniated discs in my neck and might have a couple $100,000 claim later?
No, so
Are you sure about that?
So that's a question of the definition of same transaction or series of transactions and whether the claims could have been brought. If you had no knowledge, then that would play into the discussion at the court level, which is a fact-by-fact, case-by-case basis, as to whether it arose out of the same transaction or series of transactions. It could or could not have been brought. But res judicata, whether it applies, is a different question.
Tell me how.
So I guess I could break it down as a 2-step inquiry, if you
Go
will.
ahead.
The first step is, does res judicata apply? And if so, how far and how broad does that application extend to bar further actions?
Well, here's the problem with it. Is it a new claim, or is it a claim that's worth more because of subsequent information? It doesn't seem to be a new claim. It seems to be a claim that's worth more because of subsequent information. And what, in effect, I'm concerned from a public policy point of view, not in this particular case, but in broader cases, that we would be allowing small claims court to restrict the jurisdiction of higher courts, such as county court, state Supreme Court, who make those fact-finding determinations in a number of settings for much broader damages claim and unlimited jurisdiction and unlimited financial jurisdiction also.
Right, so you're right. There is a concern there, and you have to balance the competing interests here. Here you have two interests. You have an interest in making sure that plaintiffs who are unwitting don't unknowingly waive their claims, right? But you also have the competing interest of making sure there's not repeat litigation.
Well, that's what the offset provision is for. Isn't that what it's there for? To protect a defendant who's been hit for a certain amount. He can't be hit for that same amount again. Whatever they paid in my scenario for $2,000 for damages, they'll never have to pay that again. Other issues that can arise as a result of it is a separate question. But here, you're saying that the determination as to everything would be final.
So the public policy, the reason behind res judicata is a bit broader than specifically making sure there aren't double damages. It's about relitigating and plaintiffs obtaining a second bite of the apple.
And that's
It's focused on-
because of the transaction cost to society and having proceedings and those sorts of things?
Correct.
So in the case, though, where the first proceedings in small claims court, where there typically aren't lawyers, there's no discovery, you don't have most of the trappings that make litigation expensive, isn't that concern diminished somewhat?
No, Your Honor. So first and foremost, just to address a prior point about the fairness of the situation. When plaintiffs enter small claims courts, they sometimes and quite often are not represented by counsel, right? But the system, the legal system balances those competing interests by first giving those plaintiffs advance warning, giving them resources and notice that, look, you can have a claim preclusive effect of proceeding in small claims court. To answer your question directly, I think it depends on the case-by-case basis, but continuously having to relitigate a case certainly has cost in the small claims court system. It has cost to the defendants.
Yeah, my only question is, aren't those costs less? That is, if the first trial had been in Supreme and the second was in Supreme, we'd think more about cost than we would if the first is in small claims, no?
I think that's a fair assessment. It's not true in every situation where the cost is automatically less in small claims court, but certainly we would expect it to be quite often. So we talked about public policy, and I think comparing the public policies of collateral estoppel versus res judicata makes the point a bit clearer. We talked about res judicata. The purpose is to prevent second bites at the apple and repeat.
So the consequence, if we agreed with you, the consequence is that a claimant like the individual in this case cannot go to small claims court, because it sounds like it's quite the disparity between the amounts available at the time when she filed in small claims court versus what she's seeking in the federal action. And so the only recourse is to not pursue any action in small claims court. Is that correct?
That is partially correct, Your Honor. When they proceed, they receive, back when this case first arose, the facts, they receive a notice that if your claim is over $5,000, don't proceed in small claims court. You need to, seek counsel and pursue in a different court.
Well, that claim wasn't over $5,000, right? So your point is that there are a bunch of other claims that are going to be over $5,000, correct?
Exactly, Your
So
Honor.
it's not so obvious, the notice, if you're arguing she's on notice. I'm not so sure that notice argument is that strong, but...
Yep, correct. That notice also talks about claim splitting. If you have other claims, it says, you could be precluded from raising those claims if you don't raise them in this action. So when you combine those two warnings, if your claim is over $5,000, maybe don't pursue in this court. If you have other claims, pursue those all in this court if you can. I think that covers that, the required warning to balance those competing interests.
Does the monetary limitation affect at all the analysis about your opportunity to bring an action? And she's got claims that exceed the jurisdictional cap. She could not proceed in small claims on those claims, right? Because she can't get the full remedy she's seeking, right? Does that at all influence your analysis on the res judicata effect?
No, so the law precludes her from, with respect to the jurisdictional amount bar, that doesn't bar you from raising the claim. It just sets the upper limit of the amount of damages, so you sort of pigeonhole yourself if you bring that claim. in that
Let me
way.
ask you if you can read the statute and legislative history together in the following way. That if you look at the legislative history, it cites several cases. And then when you look at those cases, those were all basically the Supreme Court or courts of instance, they're essentially lower courts. But all those cases are cases in which the plaintiff in small claims court lost. And you could read the legislative history and the statute, perhaps, to say the res judicata effect is if you go to small claims court and you lose, you're going to be barred from bringing a subsequent action in a higher court. But if you go there and you win something, you're not barred. What happens is the reduction is set out in the statute. Is that a plausible reading?
I don't think that is, that's not reflected in the statute. It's not reflected in the legislative history. It's not expressly reflected in the case law. You have to sort of imply different things. And those are cases going back to, I think, the 1990s, well before this amendment occurred. So I don't think that's a plausible reading from those cases.
So what do you view as the meaning of the first sentence? A judgment obtained under this article shall not be deemed an adjudication of any fact at issue or found therein in any other action or court.
That first section addresses exclusively collateral estoppel. The second section then provides an offset when there are the same facts, issues, and parties, if a situation like that could arise.
Thank you, counsel. Counsel?
Thank you.
Yes, Your Honor. Your Honor, one of the biggest obstacles for the defense throughout the litigation has been the inability to identify a case in which you can bring a subsequent claim. Because if res judicata eliminates all claims that were or could have been brought, then, and if you still say, well, collateral estoppel doesn't apply, but they can't identify any examples. When you have a set-off provision, that's aimed at identical or very similar causes of action. For example, you're discharged because of your gender from your job. That's covered under the city law, the state law, and the federal law. You sue under the city law, the issue of whether you were discriminated against is the main issue. Each one of the claims is a separate claim. So then let's say you whatever happened in the city case, you then bring a federal case. The issue is still the same, but you can bring the claim again. Let's say you recover more money. Let's say you recover $10 in the city claim.
In your view, can you bring that claim again if you lost the first time?
Yes, yes.
So you can fully litigate an employment discrimination case in small claims court, lose, and then bring it in federal court?
But it wouldn't be the same claim. It would be a state claim involving the same facts.
Well, let's not use your employment discrimination example then. Let's say it's just a breach of contract. I'm going to sell you my bicycle for $1,000. You claim there's a contract, I say there's not. You take it to small claims court, you lose. Can you then bring that claim in another court?
No.
Why?
Under the interpretation that we put forward, it appears from the legislative history that the 2005 change in the law was intended to preclude you from bringing the exact same claim. Before that, there was no preclusion as to the claim. You could bring the same claim again, and judges complained about that. Before 2005, you can bring the same claim, but only seek a set-off as to the amount. After 2005, you were precluded from bringing the exact same claim. But you can bring a different claim under a different legal theory or under a different law based on the same occurrence or incident. Right? And that's what distinguishes the small claims court from every other court. There is no, and Judge Stein mentioned policy consideration. Yes, res judicata is intended to ease the burdens on the court, but the legislature made a policy judgment to limit it because there's more compelling interest in terms of the lay people that use the small claims court. A single mom, as I pointed out, like the plaintiff here, who lost her wages, who wanted a quick remedy to pay her rent. She shouldn't have to surrender her federal statutory rights in order to use, that's a heavy price to pay to use the small claims court system. And it goes against the statute. Once again, the statute becomes meaningless, absolutely meaningless, if the defense's interpretation is adopted, because you will never have a case where the set-off provision will be implemented or applied. It'll be zero.
Thank
And the
you,
language
counsel.
itself, which allows a subsequent action based on the same facts and issues, will have no meaning. It's been 2 years. They have yet to identify one case in which their interpretation would allow.
Thank you, counsel.
Thank you.